Did you know that you can protect your unique graphic t-shirt designs with U.S. design patents? Hello and welcome. I'm U.S. Patent Attorney Eric Kelly. First, an extremely important timing rule to be aware of. If you fail to have a patent application prepared and filed within 1 year of a first public disclosure of your design, then you will be forever prohibited from obtaining a U.S. patent on what was publicly disclosed. We'll go over that timing rule later on as well. So if you do not timely take steps to establish intellectual property rights in your designs, then others may be able to copy and or sell your designs without your permission and without owing you anything. Depending upon a variety of factors, graphic t-shirts, clothing designs, and merch designs might be protected by U.S. design patents, U.S. copyright, U.S. trademark, and or U.S. trade dress law. In this video, I will focus in particular on the use of U.S. design patents to protect unique designs for graphic t-shirts. However, U.S. design patents may be used to protect any clothing product, not just t-shirts, and or used to protect other merch products that have unique designs. So the U.S. design patent will work as long as the design shown in the U.S. design patent application is novel and non-obvious. If you obtain a U.S. design patent, that gives you 15 years of protection. It keeps others, you can prevent others from making, selling, offering to sell, importing into the U.S., and or using whatever design is shown in the drawings of your U.S. design patent. So the protections offered by U.S. design patents are very powerful and useful. Note, what you're seeing here in this intro slide are just the cover page portions of some example U.S. design patents that deal with t-shirts. This is all public record information. I will show and discuss these example U.S. design patents later on in the video. Next, we're going to talk about that 1 year filing deadline in a bit more detail. Because not every design you come up with will be a good seller, you might want to adopt a strategy where you only have the U.S. design patent application prepared and filed for a given design that is selling well. However, keep in mind that the U.S. design patent application must be prepared and filed within 1 year of your first public disclosure of the design, as we just mentioned. So that means once you have a launch of a given design, once a given design becomes initially public, in reality, you may only have about 10 months or so from that first public launch date to evaluate your sales, and then if the sales are good, to get the U.S. design patent application prepared and filed before that 1 year hard deadline gets triggered. Note, in a rush scenario, it may be possible to prepare and file a U.S. design patent application in 1 or 2 days. However, it's much safer to generally allot 1 to 2 weeks to prepare and file a given U.S. design patent application. Okay, next we're going to diagram this hard 1 year filing deadline to keep in mind. So right here is just an indicator of which direction time is moving. The arrow is pointing towards the right. Then over here in this block on the left here just indicates the time it takes for you to actually develop a particular design. And then the next block right here just indicates when that design is 100% finalized. And during this time period in general, where you've done the design development and you finalize design, that's where you want to keep the design secret and confidential. So then after the design is 100% finalized, in theory, that's probably when you would have your public launch. So that's shown here on this diagram as the first date the design becomes public. Then next you have this chunk of time over here is where you would want to get your U.S. design patent application prepared and filed, and that has to be less than 1 year from after that first public date. Okay, if you were to get the design patent application prepared and filed after 1 year from that first date the design became public, that's going to be too late to receive a U.S. design patent application, or to get the benefit of a U.S. design patent at that point, because you'd be prohibited from obtaining a patent on that at that point in time. Additionally, just another point here to make is whoever is doing the design, you want to make sure that you actually own the relevant intellectual property rights in the design that's being developed. So if you're doing the design work yourself, that's not a problem. If you have an employee that's doing, and not an independent contractor, but an actual employee that's doing the design work for you, that's also not a problem. However, if you're having an independent contractor do the design work for you, then you absolutely want to have in writing some type of assignment where that designer is actually assigning their rights to you, so you own the rights. Okay, next we're going to talk about some specific US design patents, and the first one we're going to look at is US design patent D947499, which is pertaining to a t-shirt. So here you can see the cover page of US design patent 947499. Just looking at the cover page, up here you can see the actual US design patent number. Here you can see the date when the patent issued. So this patent is good for 15 years from this date. Again, you can see the term here, 15 years. Here you can see when the patent application was filed. Okay, so it was filed in 2020 and it issued in 2022. So that gives you an idea how long it takes to obtain a US design patent. Over here, you can note the attorney or US patent attorney or patent agent who actually prepared this or worked on this US design patent. And it was not me, so this is not a client of mine. This is just a US design patent I found doing some research. And here you can see the title, t-shirt with stylized logo. Next we'll look at some of so there's 7 figures. Over here you can see that there's 7 figures. We'll look through these here in a second here. So here's the first figure, and this is what we would call a perspective or isometric view. And the main thing to note here is that the entire drawing, the entire figure is shown in solid black lines. That generally means that the entire portion of what you see here is being claimed as part of the protected design. We'll see some later examples where they use broken lines, what we call, or you might think of as dotted lines, that actually show parts of the design which are not claimed. But here the entire shirt as well as the graphic portion are being claimed. So here's just the front, here's the back, side views, top and bottom views. So that's the 7 standard views. So you have 1 perspective view and then the 6 standard orthogonal views. That's pretty typical for US design patents, no matter what it is you're showing. But sometimes, like for something like clothing, you don't necessarily have to have 7 figures, and we'll see that in some of these other examples. Okay, next we're going to look at US design patent D624728. And again, this is on a t-shirt. And so this one has only 5 figures, whereas the last one had 7 figures. So we'll look at the figures again real quick. And again, note that it's all solid black lines shown here, which means that the entire shirt as well as the graphic portions are being claimed as the protected design. So the top and bottom views are not being shown here. Okay. And also note, I'm not going to be giving any kind of judgment about whether the graphics shown are good or bad or whatever. But this is an issued US design patent. Okay, so this is an example of things that can be protected as long as when you file this, you're the first person to do this. It's novel, and the design also has to be non-obvious. You can meet the novelty and non-obvious requirements, and the drawings are done appropriately, then you generally can obtain a US design patent. Okay, next we're going to look at US design patent number D860585. This is on a t-shirt with animated character image. So note here, this only has 2 drawing figures, whereas the first one had 7, the second patent we looked at had 5 figures. This particular US design patent only has 2 figures. It's just the front and back. We'll look at them in a little more detail here. So again, notice that the entire design, as well as the outline of the t-shirt itself, are shown in the solid black lines. That means this entire design that you see here is being claimed as being protected. Now, these little portions here, these are the shading lines, and those portions are not part of the protected design. And then the next figure is the back side. Now notice on this particular US design patent that the applicant also included his trademark. And if you look on the cover page, which also has the specification, there's a little note about the trademark. It says the trademark material forming part of the claimed design contains the word Delano appearing in a circle and a TM under the circle and is owned by the inventor. So if you do include a trademark, you often will need to have some language like this that indicates that you're also the owner of that trademark. And if you're not the owner, then a different type of language needs to appear there. Okay, next we're going to look at US Design Patent number D692639. Again, this is on a t-shirt. This particular US design patent has 6 figures. And one of the reasons I'm bringing up this particular one is this is the first example we're going to see that are using broken lines. So here it says the broken lines in figures 1 and 2 represent stitching. So when we look at the figures, figure 1, essentially, at least to me, it looks like everything is being claimed because everything's shown in solid black lines except for the stitching, which is shown in broken lines. And here's just a look at the other figures as well. So here's figure 2, front view. Figure 3, rear or back view. Figure 4 is going to be a left or right side view since they're the same. They're symmetrical. And then figures 5 and 6 are your top and bottom views. Now, when I actually do look at this one, I can't necessarily tell the difference between what this applicant is thinking or intending to be solid black lines versus broken lines. But if you set that aside, and just look at the fact that, at least here in this language, the broken lines in figure 1 and figure 2 represent stitching. So when you're using broken lines, that actually means, or generally it means, that the actual protected scope of the design is actually larger than had they not used the broken lines. Because here they could use any kind of stitching they want, and that's not going to change the protected element of the design since the stitching in itself is not being claimed. So appropriate use of broken lines can actually result in a US design patent application that has broader protection than it might otherwise have. Okay, as a recap, so for the first 3 US design patents that we looked at, addressing t-shirts, solid black lines were used in the drawings, so everything was claimed in the drawings. No broken lines were shown in those drawings. And in the 4th US design patent we looked at, everything was claimed but the stitching. Okay, so next we're going to move on to 3 other US design patents where only the graphics portion is claimed. And the first one of these is US design patent D754943. So again, you can see that the subject matter of this US design patent is a t-shirt. And here, there's only one drawing sheet, only one figure. It says the sole figure. And you'll also see a broken line statement here that says, the broken lines shown in the figure are for the purposes of illustrating environmental structure and form no part of the claimed design. So the entire t-shirt essentially is shown in broken lines, so that portion of the design is not being claimed. And it's only the graphic portion that is actually being claimed. So this actually, at least in my mind, yields broader coverage or protection. Okay, next we're going to look at US Design Patent D808665. This is on the subject matter of a t-shirt logo. here there's 4 figures. And again, there's a broken line element to this one. So the entire shirt, again, is shown in broken lines, whereas the graphic portion is not shown in broken lines. So here the broken line statement says, the showing of evenly broken lines is included for the purpose of illustrating environmental structure and forms no part of the claim design. Now this one is also interesting because it includes essentially a logo here, the panther, and then there's a statement here that says, applicant acknowledges that panther logo forms part of the claim design, is registered and owned by the University of Northern Iowa. So this is an example where if you're trying to include a trademark of someone else, you'd have to include some kind of statement here to that effect. And then looking at the drawings in closer detail, again, you can see broken lines showing essentially the t-shirt portion, and then for the actual graphic aspects of the shirt, this is the design portion that's being claimed because it's drawn in the solid black lines. So this is the front of the t-shirt. Then we have side views, 2 side views, left and right respectively. They could have just did one drawing here, assuming that the left and right side views are symmetrical, or they could have probably omitted them altogether. And then here's the rear of the shirt, again showing the t-shirt portion, the actual shirt portion drawn in broken lines, which is not part of the claim design, and just the graphic portion that is being claimed. So in theory, this design could have also been put on a hoodie or a sweatshirt or something to that effect, because the actual shirt portion is not being claimed. So this again gives you some broader protection. Okay, next we're going to look at our final example where only the graphics portion is being claimed as the protected element of the design. And this is US Design Patent D767287. Subject matter for this US Design Patent, the title here is a t-shirt. And one of the other reasons I'm showing this particular example is because the 2 different embodiments of essentially the same design are being shown here. And by that, we'll look at the next sheet here. So figure 1, figure 2, you'll notice that the protected portion of the design, which is shown in the solid black lines in figure 1, is slightly different looking than in figure 2. So this US Design Patent actually has 2 different embodiments. It's kind of 2 different versions of the design that are actually being claimed and protected. And again, the basic t-shirt element is being shown in broken lines, whereas only the solid black lines, that's the claimed design portion, the part that's actually being protected, is shown in the solid black lines. Okay, next we're going to look at US Design Patent D942124. And this will be an example where instead of using black and white line drawings for the patent drawings, photographs of the t-shirt were used instead. And that is acceptable. However, it's not necessarily preferred because you can't do some of the things like using broken lines to get broader protection that you can do with the black and white line drawings. In any event, let's take a look at this US Design Patent. Okay, subject matter, the title here is a t-shirt. Then we'll go to the drawings here. So this is the first drawing. Again, it's a photograph. And here's the of the back of the shirt. You can kind of see the wrinkles and things. So photograph of a t-shirt. Here's the back. Again, here's the front. And then this is the graphic element for this particular US Design Patent. Again, I'm not making any judgment calls as to the quality of the graphics appearing on this US Design Patent t-shirt. This one is also interesting because it says that at least one, if you look here under the description, it says here that at least one of the drawings, which is really photographs, were executed in color. So when the US Patent Office prints the patents out, like you can see here in this PDF file, they're always in black and white. So you never can see any color. And generally color is not included in patent application filings, but it can be in certain instances, and this just happens to be an example where color was included, but it's not. You can't see it here in the PDF file or in the actual printed patent, but there's this note here that in the USPTO records there are color drawings here, so you could pay a fee to get a copy of those if you were really interested. Okay, here's our final example of a US design patent dealing with t-shirts that we're going to look at today, and this is US design patent D638607, and this will be an example where the graphics portion is not being claimed as part of the protected design. So again, we can see the subject matter title for this US design patent is a t-shirt. And then we'll look at the drawings real quick. So you'll note the graphic portion is actually drawn in broken lines, which indicates that's not being claimed. There's another graphic portion here on the side and bottom down here, again drawn in broken lines. It's not being claimed. You can see a graphic portion on the front of the shirt and drawn in broken lines here, not being claimed. And then here's a graphic portion on the back of the shirt, drawn in broken lines, which is also not being claimed. And you'll notice too that from the front and back, there's a difference in shading, which is being claimed. Okay. So here's the full back. And again, the graphic elements are not being claimed because they're being drawn in broken lines. So if we go back to the cover page, you can see these points here. So this is with respect to the broken lines, and it says the even dashed lines showing the football is included for the purpose of illustrating environmental structure and form. It should say forms no part of the claimed design. The dash, 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 dot, dot lines showing the stitching in the collar and hemline of a t-shirt are included for the purpose of illustrating environmental structure and form no part of the claimed design. And then again we have the broken line shown in the drawings as forming the words ASU and Arizona State represent unclaimed portions of the design and form no part of the claimed design. And here's where we get to the difference from the front and back. The diagonal lines are included for the purpose of showing surface shading and are meant to indicate contrasting color, contrasting materials, and or contrasting surface treatment. So this just wraps up the various US design patents that we looked at dealing with t-shirts. Okay, so what you're seeing here is just a summary table of the 9 different US design patents that we looked at on t-shirts. So you can reference any of these on your own, check them out. So you can use any of the free patent search engines to pull up any one of these or all of these US design patents. So you could use Google Patents, you could use free patents online, or you can go to the USPTO and pull them up as well. So just as an example, we'll go over to Google Patents. If I enter one of these US design patents, US D947499, and again, it automatically just shows you t-shirt with stylized logo. We'll go ahead and click on that. So this is an example of using Google Patents to pull this up. You can pull up the actual PDF file, of that particular US design patents. This is how it actually looks in real life. Right, and then as another free patent search engine, we can go to Free Patents Online, freepatentsonline.com. And normally when you first come to this page, you're brought over to the expert search page, but what you want to do here is go to the quick search, and where it says document number, you want to enter the particular patent number. So here we can be D947499. And we're going to be hitting the search button, but you can also go down here and see you can search in other databases, but we'll be looking for US patents. Search. And again, if you want to pull up the actual PDF file of this particular US design patent, you then click on download PDF. And again, here it is, right? It's the same one as that we pulled up from Google Patents. So that's just how you can access any of these US design patents on your own too if you want to do further research on this. Okay, we're ready to wrap up this video. So we've looked at a number of different US design patents pertaining to t-shirts. So basically the whole point of this video was to illustrate that if you have a novel and non-obvious graphic t-shirt design and it either is selling well or you think it's going to be selling well, you should really look at going after and pursuing obtaining a US design patent to protect that design, to prevent others from basically copying and using your design without your permission. Okay, so that's the whole gist of this video. So if you're interested in working with me, you can see some of my contact information here. You have a couple of different emails for me and my phone number, which works for phone or text. And as noted here, I'm a US patent attorney, Eric Kelly. I work with clients from all over the world and all over the United States, all over California, local clients as well as non-local clients. I'm an intellectual property attorney, a patent attorney, trademark attorney, copyright attorney. So I do handle US patent matters, US trademark matters, and US copyright matters. In this particular sample video, we were focused on US design patents, but I also handle, trademarks for branding and copyrights for protecting other creative content. So thank you for listening. Please subscribe to help me reach others about intellectual property matters. If you subscribe, the algorithm is more likely to suggest this video to others. And here's some suggested videos on additional US design patent matters.